Good morning and welcome. We're pleased to have you with us today. We have 4 cases on the morning docket, and we will call them in the order in which they appear. Let me remind counsel that each side, whether you have 1 or 3 appellees or appellants, has a total of 15 minutes, and if you'll need to share that time, and if you haven't decided on how to share it, we'll help you do that. But the appellants also have the right to reserve up to 5 minutes for rebuttal. So when you come to the podium, after you've introduced yourself, let us know how many minutes you wish to reserve, and we will program the clock accordingly. Are there any announcements or introductions? Hearing none, call the first case, please.
In re Estate of Nancy Riss.
Good morning.
Good morning, Your Honors. May it please the Court, my name is Mitchell Miller for the appellant, Adam Riss, and I'd like to reserve 4 minutes for rebuttal, if I may.
4 minutes, certainly.
Your Honors, Mrs. Nancy Riss executed a will that included both of her sons, and she later determined, after a litigious and fraught relationship with David Riss, that she wished to exclude him from her estate. In connection with some other litigation, she executed 2 documents for that purpose. One is a typewritten codicil, and the other was a handwritten document. And both of those instruments are before you today on appeal from the trial court granting motion for judgment on the pleadings. The appellee submits that neither document is valid. We urge the court that both documents are valid under the various statutes that apply here. I'd like to talk to you first about the typewritten document in question. The typewritten document is a 1-page document, and I'd like to emphasize that to the court because all of the other case law on this particular point seems to involve documents where there are multiple pages, and the dispositive issue here may be that witness signatures appear on a physically separate page. That is not the case here. In this particular handwritten document, the testator has a very simple 1-paragraph top portion of her typewritten document, which she has signed in compliance with the will execution statute. And at the bottom of that 1-page document, her witnesses have also signed the document. We submit that these 3 signatures on this 1 page create a valid codicil under Tennessee law.
So under your theory, the signatures on the affidavit portion could serve 2 purposes. They could both witness and serve as an affidavit.
Not necessarily, but I take your point. We agree with one of the holdings of the estate of Morris, which is the precedent that the trial court relied upon exclusively. Under Morris, there is a distinction, and the statutes make clear, there is a distinction between executing a will and executing an affidavit. We respect that there are different documents here, and that you cannot have witness signatures on an affidavit that serve both purposes unless you fall into subsection B of the will execution statute. We agree that that does not apply in this case. We have to comply with subsection A of the will execution statute. We submit that the witness signatures on this bottom portion just need not be considered signatures on an affidavit. The estate of Chastain makes clear that the location of a testator and witness signatures on a testamentary instrument is really not a dispositive factor because the statute is silent on that issue. This 1 page contains all of the signatures that we need. We would not be able to use that paragraph as an affidavit to create a self-proving will. We would not do that.
Well, how do you treat it for the purposes of the will but ignore the attestation affidavit? How do you get to pick which one?
Well, this case has I'll answer that directly. First of all, the intention of the signatories should be evidence that the court considers. All the signatories to this document clearly intended to execute a valid codicil.
Well, why wasn't that the case in Morris?
Morris had a separate page, and we submit that that does make a difference.
But the top of that page, wasn't the top of that separate page the ending of the will?
That's kind of what the court said in that case, and then
Well, isn't that the fact?
sure, because the court said so. And the second page in Morris that contained the witness signatures had a separate heading. It was very clearly intended to be an affidavit as a separate page that would be attached to a will.
Well, why doesn't this one clearly indicate that their signatures were the affidavit?
We think because this is a one-page document and all signatures are on the same physical piece of paper and they were all executed at the same time and place in compliance with the will execution statute, that it satisfies. And the remedy would be just say that you cannot use this affidavit language as testimonial language for purposes of making it a self-proving will.
But in response to In re Estate of Morris, the legislature carved out an exception for certain wills. And it sounds like what you would have us hold in this case to avoid overruling Morris is to carve out yet another exception, one that the legislature very well could have done themselves.
I take your point. And we think that the exception the legislature created doesn't, that this court has another remedy. The Section B of the will execution statute says that if we're using a separate affidavit to make the will whole and to make it valid, then you have to comply with Section B, and you still have to go through all the separate issues of testimony, either live testimony or additional affidavits to admit the will to probate. We would say that in this case, you need not consider this affidavit as dispositive. It doesn't need to be a separate document. All the signatures are on one page. Under Chastain, the location of the signatures really doesn't matter, and we know that we can't use the testimonial nature in this case for two reasons. First of all, you can't double dip, right? And that, I think, is what you're getting at. We cannot use the witness signatures to make a valid will and also admit the will to probate.
So your position would be use the signatures even though they appear below the affidavit as if they were witness signatures, and as a consequence of that, you don't take advantage of the self-proving affidavit.
That's correct. And the additional factor in this case that's relevant is that the appellee has filed a will contest on other substantive grounds. So we would not be able to, on undue influence, duress, and so forth. The consequence of that is that we could not use the affidavit to admit the will to probate anyway, because those witnesses would have to come in and give live testimony in order to admit the will because of the contest nature of this case. So if this will is invalidated at the outset because we consider this to be an affidavit, and then we can't actually use the affidavit for its intended purpose, we get into kind of a weird result here that bears no resemblance to the testator's intention. So that is our position on the typewritten document. I only have a couple of minutes left. I'd like to talk to you about the holographic document as well.
On the holographic document, you say that it incorporates by reference the typed will, codicil.
We have two arguments about the holographic document.
I've read the handwritten document twice, and I haven't found that language.
I will admit that it does not include the explicit, I incorporate this by reference type of language that we as lawyers would like to see.
If you don't have that language, how does it incorporate the typed document?
We believe that any construction of that document needs to give effect to all of the language in the document. And there is a phrase at the very beginning that says, as a codicil to my will. And so our point is that language has to mean something. It either means that I'm incorporating this other typewritten document so that these two together make a codicil, or, and this is our second argument, that means Mrs. Riss is announcing the handwritten document is itself a codicil. So,
But she doesn't reference it. She just says this is a codicil.
and so,
This doesn't say this is my second codicil, or this codicil incorporates by reference another codicil that I executed on a certain date.
which is why we believe the stronger argument is that the handwritten document is itself a holographic codicil.
And how do we know who receives what from her estate from the handwritten codicil?
So and I think that's where the trial court made an error. The trial court said that the handwritten document does not contain dispositive provisions. It's important to remember that a codicil is merely an amendment to a will. So a codicil need only make some change to the will. It can be administrative or it can change the disposition of property. Whether this document is a testamentary instrument is a factual question for the jury, which we never had an opportunity to present to a jury. The question is whether this handwritten document was intended to have testamentary effect. And we believe that there is a jury out there that could easily determine, based on that handwritten document and the other extrinsic evidence that would be admissible, to show the testator's intention for that document to have testamentary effect. The operative language, she has this preamble, and then she lists a lot of reasons and grievances. The operative language would be the bottom paragraph that is not numbered that says, for these reasons and more, I wish to have no further relationship with David Riss and his family and so forth. Their only interest is my money. That would be a question of interpretation. So the first question would be, jury, is this a testamentary instrument where Mrs. Riss intended to have some effect on the administration or disposition of her estate? If the jury says no, document's out. If the jury says yes, the question of interpretation of this provision goes to the judge for a legal determination of what does this mean. And the judge would be bound by the jury's determination that this is a testamentary instrument. So the construction would have to give some testamentary effect to that document. So we believe that that is probably our strongest argument as to the handwritten document, why this case should be remanded for additional proceedings on that front.
All right, thank you, sir. We'll hear from you on rebuttal.
Thank you.
Good morning.
Good morning, Your Honors. My name is Matt Hausman from Martin, Hiller, Potempa, and Shepherd. I represent the appellee, David Riss. I refer to him throughout the brief as the petitioner because that's how he's referred to it in the original thing. So if I switch back and forth, I apologize for that one. Your Honor, as the appellant's counsel brought up, there's two documents at issue here. A typewritten document and a holograph and handwritten document. Your Honor, we submit that neither of these documents constitute a valid codicil, or nor do they change the disposition of the estate. As counsel brought up, the heart of this issue has already been decided by this very court in 2015 on the appeal in the estate of Morris. The trial court even said in their order that this case was indistinguishable from Morris. The fact that it's a one-page document doesn't change the fact that it does not meet the statutory requirements. Just as in Morris, the testator signed directly below the signature on the same page, there is an affidavit, clearly identifies itself as an affidavit, and is signed by people who identify themselves as affiants. Under the ruling in Morris, that does not make a valid codicil or a valid will because it requires them to have two signatures, and then a separate statute says you can use a self-proving affidavit. Again, this case and that document is indistinguishable from the one that was decided in this court in the estate of Morris.
In Morris, well, the trial court in this case, citing Morris, said that in Morris, the affidavit began on the same page that the will ended. That appears to be the same set of facts we have here.
I agree, Your Honor.
The affidavit began on the same page.
Yeah, and as they explained in Morris, the statute's very clear that the affidavit can be included. It even says it shall be included on the will, but if impractical, then it can be used as a separate document. That affidavit was on that will, just as, or on that attempted will, and just as the affidavit is on this attempted will, the length of the pages doesn't make a difference, because if you look at the facts in Morris, if you had the signature of the testator and then you didn't have that affidavit and you had the signature of the two witnesses, they wouldn't say, well, these aren't all on the same page, these aren't all on the will. It would say this was just a continuation. This is all one document. And that's the same thing we have here. The fact that it's one page doesn't change the holding in Morris. And this case and that document should be treated the same. Your Honor, he also brought up the holographic document. I thought the trial court, Judge Woodruff, did a very good job of explaining the fact that there are no dispositive provisions in that. The statute on holographic wills in this state says that all material provisions must be in the handwriting of the decedent as well as their signature. There were no dispositive provisions, Your Honor. It was a list of grievances, as the trial court pointed out, of why they might want to change their will. But you can't take that holographic document and say, I know how this estate is supposed to be distributed. It doesn't say, I'm changing my will and I want to incorporate this other document that I'm executing. Essentially, Your Honor, as my mom always used to say, 2 wrongs don't make a right. The appellant is trying to take 2 documents, both of which are statutorily deficient, and saying, well, if you combine them, then we have a valid change to the estate. And Your Honor, our argument is that's just not how it works. And that's how the trial court felt as well. The holographic document didn't meet the requirements, which is a question of law of whether or not this document is a will. And the trial court found that it didn't dispose of any property, therefore it didn't include all material provisions. Appellant's arguing that this is actually a factual question, but Your Honor, we submit to all of the facts. We're not saying that the document doesn't say something that it says. We say that all of the facts on the document, everything is as it was, or as it's purported to be in the counter petition that the appellants raised. But considering all of those facts and admitting all of those facts, this does not meet the statutory requirements, which again is a question of law for the trial court to decide. And that's how they decided. Judge Woodruff very succinctly pointed out that the dispositive provisions aren't there. This case is different than the argument that the appellant used for Tipler, where there was a holographic codicil, but the testator said, I want to dispose of my estate in accordance to my husband's will. That included a dispositive provision. This holographic document does not, Your Honor. And again, it may sound catchy, but 2 wrongs doesn't make a right. This document is not a valid codicil under the laws of Tennessee, and the typewritten document is also not a valid codicil under the laws of Tennessee. I believe the trial court's holding should be upheld in consideration with Morris and the supporting case law that was included in that order. And Your Honor, I know I have more time, but I believe that's all I have.
Well, we'll let you save it for another argument on another day. How about you?
I'm going to hold you to that, Your Honor.
But I won't be on that panel,
Of course.
Thank you. Thank you, Mr. Hausman. Mr. Miller, your rebuttal. Would you like to use his extra time, or?
I sure would, Your
Yeah,
Honor, but I'll leave it for
He
him.
might object to that.
I think he's going to need it someday in the future, so I should
good.
keep it. Your Honor, I will, acknowledge the facts of Morris and make a distinction. The will in Morris was professionally drafted. It had all of the hallmarks of a very formally prepared will. This one does not. This is a 1-page deal. This was done very quickly. It should not be held to the same kind of formal standard that was stated in Morris. And I'll be careful what I'm...
Well, wait a minute. You're saying we need to carve out an exception for a will that was made quickly?
No. I'll clarify
That's
that.
what I heard you say.
The will execution statute in Tennessee has to be complied with strictly. That's settled law. We don't dispute that. What I am saying is that in Morris, there is a significant discussion about why affidavit is given such a weighty, it's given great legal weight because the term affidavit and the language in that phrase. The court goes on about a discussion that if it's a legal term, it means a specific legal thing. I'm saying that that does apply in a very formally drafted will where a lawyer prepared it. Morris even says that. This case is a little bit distinct in that way. I would just note that this is a different kind of document. It's prepared differently. Doesn't have the hallmarks of a formally prepared, will by a lawyer that really intended the word affidavit to be affidavit, right? I want to focus on the holographic document. Under the Rule 1202 standard, the trial court should grant the motion for judgment on the pleadings when there is no set of facts that my client could prove to prevail on his claim. We submit that a jury could determine that the holographic will is a testamentary instrument.
So what would you point us to in your counterpetition, a factual allegation, that would have gotten us past the actual documents themselves?
Oh, you're asking about what allegation kind of ties us in?
You're saying, let's look at this from a standard review standpoint, and I agree, we're looking at a judgment on the pleadings here. And so the court had before it a petition and maybe an amended petition and counterpetition, and you're saying, well, there could have been facts here that took us beyond the documents to explain how these integrated into a valid codicil here is basically not quite your argument, but a summary of what I'm getting here. Then there would need to be some factual allegations in your counterpetition where the court could say, you know what, if I had proof on this, that would take us outside the documents there. So what allegations in that counterpetition should we be looking at?
I'm not sure if there are, if there are allegations that really expound upon the extrinsic evidence that I would refer to, but I think our allegation that this is a holographic document, that the testator, intended to operate as a testamentary instrument, I think that carries the day because that is the core allegation. We allege this document is a handwritten document that satisfies the holographic will statute. She intended it to have testamentary intent. The jury gets to decide that. And the kind of penumbra of facts that might support that, they're not specifically stated in the petition, but we would certainly be able to take discovery on that issue and have a trial on that issue. We do not believe that the holographic document has to have all dispositive provisions. The statute says material terms, and it's important that when we look at the material terms requirement, we remember that this is a codicil, not the original will. So the codicil really needs to just take the original will and make any small adjustment. We think that the bottom paragraph of this handwritten document that says, I want to have nothing to do with this person because all they're interested in is my money, after reciting, I am changing my will, could be interpreted by a jury that this is a testamentary instrument, and then further interpreted, well, the only possible interpretation of this document is that this woman wanted to disinherit David Riss for all of these reasons, and that all he wants is her money. So that's what we would submit. Thank you, Your Honor.
Thank you, Mr. Miller and Mr. Hausman, for your arguments. We'll take this case under advisement.